All right, so you've just been handed your moot court problem. You know the one. It's pages long, super dense, and that deadline is, well, it's getting closer. Okay, let's dive in and figure out how to turn that mountain of paper into a winning argument. You know that feeling, right? It's a mix of, oh, this is exciting, and pure, unfiltered panic. You're probably just staring at the page wondering, where in the world do I even start? Trust me, that feeling is completely normal. In fact, it's pretty much the first step for everyone. So, in this explainer, we're going to lay out a clear step-by-step roadmap. We're going to take you from that initial, what have I gotten myself into feeling, all the way to crafting a really sharp, persuasive argument. By the end of this, you'll have a solid strategy to tackle any moot problem that comes your way. Okay, first things first. And I know it sounds almost too simple, but this is the single most critical step, and it's the one people rush through the most. Before you even think about opening a database or a textbook, your number one mission is to deconstruct the problem itself. This isn't just a casual read-through. It's a deep dive analysis. So how do you actually do that? You break it down. 1. What area of law are we even talking about? 2. Create a strict timeline of every event. Seriously, those dates are in there for a reason. 3. What are the key facts? Know them inside and out. The good facts for your side, and especially the bad ones. And 4, keep an eye out for any preliminary issues, like jurisdiction. You want to spot those before you even get to the main course of the argument. And this is a huge distinction you have to make right at the start. Is your problem governed by international law, things like treaties and customs, or are you playing in the domestic sandbox with constitutions, statutes, and common law? Pinning this down early is going to focus your research like a laser and keep you from falling down some very deep, very wrong rabbit holes. Okay, so once you've properly dissected the problem, it's time to chart your course. A moot isn't won by frantic, random searching. No way. It's won with a deliberate, strategic research plan. This plan is your treasure map. So what goes on this treasure map? Well, start with keywords and legal concepts. And I mean actual legal terms, not just random facts. Jot down any potential case names or legislation that are mentioned or even hinted at. Then, decide what types of sources you need. And, this is crucial, which specific databases or textbooks you're going to use to find them. A good plan will literally save you hours of wasted time. Now, you have to understand the difference between your tools. Primary sources are the law itself, the actual cases, the statutes, all the raw material. Secondary sources are expert commentary about the law, like textbooks and journal articles. And here's a pro tip for you. Start with secondary sources. A great textbook or article is like getting a guided tour of the subject. It gives you all the background and then points you directly to the key primary sources you need. With your plan in hand, the hunt begins. This is the fun part. This is where you actively go out and find the legal authorities that will become the backbone of your entire argument. It's an adventure, for sure, but you'll need the right techniques to navigate it. Look, this isn't Google. You can't just type a question into the search bar. You have to be smarter. Use the index and table of contents in a textbook. They are your friends. In databases, learn how to use advanced search connectors to narrow things down. When you find an article, always read the abstract first to make sure it's actually relevant. And please, please do not forget the footnotes. They are an absolute goldmine for finding more sources. It's going to happen. You're digging and digging for a very specific point. You've tried a dozen search terms, and you are just hitting a brick wall. You can feel the time slipping away, and it is so frustrating. So what do? I want you to remember this number, 15. This is the 15-minute rule, and it is a lifesaver. If you can't find what you're looking for in 15 minutes, just stop. It means either your keywords are wrong or you're looking in the wrong place. Go back to your plan, try a different term, a different database, a different book. Momentum is absolutely everything in research. Research isn't about just collecting a giant pile of information. I mean, that's useless by itself. The goal is to forge that information into a weapon, a sharp, logical, and really persuasive argument. This is where you transform all your findings into a coherent structure. And the best way to structure it? The IFL exact method. It's a classic for a reason. You state the issue. You lay out the relevant facts. You state the law you found. Then comes the most important part, the application, where you apply that law to your facts. And finally, you give your conclusion on that issue. This framework makes your argument incredibly logical and easy for any judge to follow. So you're building your argument and there it is. You find the perfect case for the other side. Your heart just sinks.
But listen, finding unfavorable law isn't the end of the world. In fact, it's an opportunity for you to show some real skill. Whatever you do, don't just ignore it. Confront it head on. First, you try to distinguish it on the facts. You show the judge exactly why the facts in that case are different from yours, so the result should be different. Second, check the jurisdiction. Is that case even binding on your court, or is it just persuasive? And finally, use a case citer. It's an amazing tool that can show you if a later case has maybe criticized or even totally overturned that problem case.
All right, you've done the work, you've built your argument. Now let's just make sure you don't fall at the final hurdle. Here are a few really common traps that even the best mooters can fall into. And look, we've come full circle. The number one mistake is not reading the problem carefully enough. Another big one is arguing the facts. Remember, the facts are fixed. You argue the law. Then there's poor teamwork, running out of time, not knowing the competition rules, and finally, reading your argument from a script. You are not there to read. You are there to persuade. You are there to tell a compelling story. Because really, that's what this all leads to. You've deconstructed the quest, you've charted your course, you've forged your sword. All that research, all that planning, it was all so you could stand up and tell the story of your client's case with absolute confidence and authority. So I guess the only question left is, are you ready?